Hello, good afternoon. My name is Vivian Cristino from Housing Action Illinois. We're gonna wait a couple minutes to see, waiting for another people join the webinar. Thank you for your patience. Hello, good afternoon again. Thank you for joining us. My name is Vivian Cristino, Capacity Building Specialist at Housing Action Illinois. Can you please raise your hand, and if you hear me? Thank you so much. Please note that this presentation is being recorded and will be available for download in our website. And also, we're going to send you the PowerPoint slides. This webinar will be discussing Illinois mortgage foreclosure process with an emphasis on the necessary steps for filing a foreclosure, typical timeline, borrower defenses and protections, and tips for what cases would make for appropriate referrals to legal aid or other foreclosure defense attorneys. Please submit your test questions and comments using the questions panel. We will answer some of them during the webinar. Today's panelist is Dan Lindsay, Director of Consumer Practice Group at LAF, formerly the Legal Assistance Foundation of Metropolitan Chicago. For more than 50 years, LAF has provided free legal services in non-criminal matters to people living in poverty in metropolitan Chicago. Dan Lindsay has practiced in the areas of housing and consumer law for over 20 years. He has advocated for local, state, and federal laws and policies promoting fair lending and due process for homeowners. Dan is a cum laude graduate of Howard Law School and magna cum laude graduate of Davidson College. I want to thank Dan Lindsay and LAF for their support and assistance in developing this presentation. Dan?
Thank you, Vivian, for that introduction. And let me just say to everybody right up front, as Vivian said, if you have questions, please feel free to type them in along the way, and we'll try to answer those that we can. And if there's questions you have that we don't get to, feel free to email me separately afterward. My contact information is on this first slide. It's also going to be on the very last slide. And I believe Vivian will be posting this PowerPoint slide on Housing Action Illinois' website, or otherwise making it available to everybody. So you should be able to do that. So without further ado, let's dive on in. Quick reminder. Back in the early 90s, this is Cook County, which is where we practice. So I understand some of you are outside of Cook County, but I'll focus some of my remarks on Cook County, and hopefully a lot of them will be statewide. But in Cook County, early 1990s, 5,000 foreclosures. As you can see, they began to rise throughout the 90s and the aughts because of the subprime mortgage crisis. And then they began to decline after the crash. After the crash, there were probably 3 to 4 years where it was still very high, and then starting in 2012, started to go down. And I'm sure, you've all sort of experienced this, that there are not as many foreclosures as there used to be. But at the same time, everything's relative, and let's be realistic. If you recall, I'll just go back real quickly. In the early 90s in Cook County, just to take Cook County as a measure, we had 5,000 a year. And as of a couple of years ago, the last numbers I have, even though it had gone way down, it was still 15,000. It was still 3 times what it was before the beginning of the mortgage crisis was on anyone's radar. So it's still pretty high. And I'm sure we're all dealing with still a lot of people facing or in foreclosure. Here's a slide that I like to put on because it tells us something about Illinois and certain other states in the union. And to make sure that you're all paying attention, we're going to have a few polls throughout the webinar, throughout the hour. And the first one is coming up. And what I'll do, let's see, Vivian, you're gonna actually do this part, right? I'm forgetting. Should I put up the next slide with the poll, or are you gonna do that part for me?
No, I'm just going to, yes, ask the question, and we're gonna just poll the poll.
Okay. So here's the question, and then Vivian will help administer this poll since she's much more tech savvy than I am. So the poll is, what do the blue states have in common on my map? And your answers are going to be, and you'll get to click in a moment. You'll see the different possibilities. You'll be able to click in. A, they trend Democratic in presidential elections. Sort of a good poll question after yesterday, right? B, they have the highest numbers of foreclosures per capita. C, they have the longest foreclosure timelines on average. Or D, these states require judicial foreclosures. So
just see those. Yeah, see the map, and I'm gonna just I'm gonna give you like a 15 seconds to answer. Okay.
And just to be crystal clear, Vivian, you're showing them the answers right now, correct?
Yes, people is taking the poll right now. Mm-hmm.
Got it. Super.
So we're gonna close the poll and share the answers. Okay. So that's the answers right now. Do you see it, Dan?
I do. I got it.
Okay.
If this works at all, everyone, it's because Vivian and I practiced this yesterday and tried to figure it out. So what I'm looking at now are the answers, and 58% of you have correctly identified the last answer as the correct question, as the correct answer. Sorry, they require judicial foreclosures. That's absolutely right. Now I'm putting that back out of the way. A lot of you also said that, oh, can I see the answers again, Vivian? You put the answers back on there for me. Thank you.
Yes.
Sorry. A lot of you also said they have the highest numbers of foreclosures per capita. I don't know if that's true or not. Some of you also said 10%, they have the longest foreclosure timelines. That's actually a pretty good guess because the fact that all of these states in blue require judicial foreclosures, meaning you have to actually file a lawsuit to foreclose on someone's home rather than just publishing it in the newspaper and going to sale. The fact that you have to go to court does make it, on the whole, a longer timeline. So that's actually a pretty good guess. But the technically correct answer is all these blue states have judicial foreclosures. So Illinois is one of them. So with some rare exceptions, and if you ever see these, please contact me, and there'll probably be foreclosures filed by HUD. But other than some rare exceptions where HUD is filing outside of the court process, you have to file in court, and it's usually in state court. So, that sort of sets the table for this whole presentation. We can skip the poll that we've already done there. Well, here's kind of the point I was making a moment ago and alluding to, since some of you said that these are the states with the longest timelines. In fact, on average, you can see that some states have timelines. Well, actually, I should say at a minimum. This is really the minimum. process. So the very bare minimum in some states down here at the left end is only 50, 60, 70 days. It's very quick when you're trying to do something about saving a home. The judicial states tend to be the ones down here, 35 and up, where you're talking about a minimum of 5 months, and then all the way up to that very longest one, which is 450 days, or do my math right, 12, 13, 14, 15 months. That's New York, by the way, the longest, and then that's judicial. Illinois is actually second, so it's at about 300 days minimum. So yes, the judicial states have longer processes and a lot more that we can do to help people, especially if we get them, to them sooner. So what is a mortgage foreclosure exactly, and how does it play out? What does it mean? How does it play out through the judicial process? So the first thing to understand, and by the way, I should actually say a little note here, that this is pretty much the same presentation that I give to attorneys. And maybe there's some attorneys on the line, but I know a lot of you are housing counselors and you're not attorneys. But I think it's good for you to know the legal process. Some of these slides will probably have information that's more technical than you need, and citations to cases and such, and we'll kind of breeze through those, and you don't have to focus on those very much. But I do think if you're helping a homeowner, whether you're an attorney or non-attorney, it helps to know the law and at least to be able to see it through that framework, and hopefully then it'll be able to help you refer people more appropriately. So we're going to talk now about what is a foreclosure. So it's a collection action on a note, and this is important to remember. It means that somebody's behind, or there's some other reason why, if they're in foreclosure, why they're being foreclosed. It's related to a debt that they owe. And that debt is a special kind of debt. It's a debt that has a security instrument attached, the mortgage. So it's really a loan, but it's a mortgage loan. The mortgage is a security instrument. We all tend to kind of say mortgages. We're really talking about loans secured by mortgages. So the mortgage, or the security instrument, obviously gives the mortgagee, the lending entity or the servicer, the right to file a foreclosure case in Illinois to collect if that person is behind. It's a means of collection. When? After an event of default. And we're going to talk about various types of default in a moment. If there is a default, then the lender or the servicer must give a notice of the default to the homeowner to give them a chance to cure if that's possible. And then if they don't cure, typically within 30 days, the debt is accelerated. It all comes due, and we're headed for foreclosure unless the homeowner can come up with the cure that it still has the ability to come up with as the foreclosure begins. So the debt's accelerated, and there's a forced sale of the home, as I said, if the homeowner doesn't come current or pay off the debt or perhaps enter into a loan modification or some such. So we're going to have another poll here. And the question, again, I'll say the question just kind of in its bare form, and I'll let Vivian administer the poll. But the question is, looking at the fourth bullet point here, where I mentioned that there has to be an event of default for foreclosure to be filed. How many different types of default do you think there are? How many distinct reasons for which a lender might be filing a foreclosure? Take it away, Vivian. As you can see, the options.
Okay, I'm going to close the poll in 2 seconds. Okay. So here are the results.
Oh, a nice spread. I like that. And I also like the fact that I kind of fooled you, because the answer is 8. There are that many, a lot of different possible reasons for default. Only 3% of you got it right. If we could identify those 3% of you, we'd give you like a gold star or something. So what we're going to do now is move ahead to the next slide and talk about what they are. There's the most common ones, of course, but then some that occasionally occur, and some with only certain types of mortgages. So we'll look at those now. here are all the types of default. So the most obvious would be the first one, the failure to make payments of principal and interest, your regular mortgage payments. And by the way, as I say in there, it's by the due date, even if there's a grace period. So any laws that have to do with default, most mortgage loans say it's due September 1st, but there's a 15-day grace period. So if I pay by September 14th, there's no late fee. But I'm still in default after the 1st. And so if there's any laws that have to do with default or policies of the lender, default really means, you're even just a day late. Okay. As many of you know, all of you know probably, you got to pay real estate taxes if you're a homeowner. So just not paying your real estate taxes can be an event of default. And typically the lender will pay them and then demand that you pay them back. And if you don't, or if they think you don't in a timely manner, they can foreclose. Same with insurance, homeowners insurance. If you don't pay, the lender will force place, sometimes improperly, and that gets into a lot of fights, but that leads to foreclosure. Waste is, there's a storm, there's a big hole in your roof, the water's pouring in, and you don't fix it, and there's increasing problems with the home, or any other number of issues of waste. If somehow that comes to the lender's attention and you don't cure it in time, that can be a reason to foreclose. Typically, this would be if, say, the city was actually initiating like code violation proceedings against you, and then the lender got notice of that. So that usually has to be pretty serious. Abandonment, similarly, the city might, move to secure a property that's vacant, or it might come to the lender's attention. It's an event of default. The next one has to do with reverse mortgages that I'm sure many of you deal with. So that's non-occupancy, where, of course, the reverse mortgagor has to be someone who's over 62 and living in the property. So you can't, move out and like leave it for, your grandchild. At that point, they can declare the loan due if you're out technically for 12 months or more, or if you go to nursing home, that kind of thing. The seventh one would be if you transfer the property other than to a spouse or child, or if the property is transferred through death and heirship. So if you transfer it to a sibling or to a friend, or you do a private market sale, obviously the lender can accelerate the debt and call it due because they did not approve the buyer as a borrower. They approved you as the borrower. And then finally, and we've seen all of these, and we've seen this last one too, sometimes the lender will at some point allege that there was some fraud in the original loan application. And typically this has to do with, you applied for a loan, you said it's going to be a residence, and then you're operating a business out of it, or it's investment or business commercial property. That can actually lead to foreclosure. So there may be more. Actually, if anybody has any more, please let me know. I'd love to expand my list, but these are the 8 that I'm aware of. And so if any of those occur and the notice is given and the problem is not cured, then the foreclosure begins. And here's the basic timeline. And if you take nothing else away from this hour, please take away the information that's on this timeline. Use this timeline if you don't already have one like this. It's, I think, very helpful, very important to remind borrowers of the lengthy timeline that exists in Illinois, again, because it's a judicial state, judicial statute to foreclose, and the timeline is pretty extensive, pretty extended. And so what this shows is that from the very first missed payment, a foreclosure complaint won't typically be filed for another 5 months, June 1st, on this hypothetical timeline. And then once it's filed, even if the borrower does absolutely nothing, okay, they can't physically be put out of the home until the very end there, which is March of the following year, which is about 9 months later. So that goes back to the process here being one of the lengthier ones. And of course, if there's some issue and someone gets involved and contests it, especially with an attorney, then this process can be even longer. And obviously a longer process gives the homeowner more opportunities to try to come up with some way to save the home, or at least make plans for their next housing situation, and possibly get equity out of the home by selling it or in some other way.
Dan, we have a question here.
Sure. Sure.
What about not paying HOA dues, the Homeownership Association?
Oh, that's an excellent question. It's an excellent question. You can definitely get in trouble for not paying HOA dues or condo fees if you're in a condo. But in both of those cases, that's not an event of default leading to foreclosure. In both of those cases, you will instead, if you're sued, be sued by the homeowners association or by the condo board, condo association. And what they'll be doing is actually evicting you. So it's a different process. And actually, of course, eviction goes quicker than foreclosure. But what would happen is if you really didn't come current and you really got evicted, the homeowners association or the condo association could evict you. You're still the owner. And by the way, you still have your separate duty to pay the mortgage lender and to pay the taxes and insurance, but you've been dispossessed because the HOA or the condo association has the right to rent out the property and pay itself back whatever it's owed, right? So if they get a judgment for $10,000 and they can rent it out for $1,000, they can do that for 10 months, pay themselves back before you're able to move back in. So that's how that would work. Great question. And sometimes we do get involved in those cases. Our whole mission here at LAF is to preserve homes, home ownership. And so sometimes if somebody is dealing with a condo board or homeowners association, we will take those cases and get involved if you're thinking about like referrals. I think, well, let me just say one thing about the timeline here and then we'll move on because I talk about some of these things in more depth, in more detail. As you can see, I've got this one line item in red, the expiration of the right to redeem. And that's in red because it is just so important. You see that there, the complaint's filed in June, the borrower was actually served, given the complaint June 15th. So the right to redeem lasts for 7 months or 3 months after judgment, which in this case is September 1st, whichever is later. So in the hypo here, the 7 months is later. So if for whatever reason it took the lender longer to get around to getting its judgment, and 3 months beyond that was past January 15th, then you'd have a later right of redemption. So in that 7 month period or longer, that's when you have the right to avert foreclosure through whatever means. So basically, once that right to redeem is over, the home can be sold. Here it's, sale is shown like happening the very next day. And once that happens, you're pretty much out of luck. We take a few cases after that when there's some legal wrinkle, but for the most part, expiration of right to redeem, that's when you have the right to sell the home, to refinance, to pay off the debt, or to get a loan modification if you're able to do that, or to file bankruptcy. That's sometimes also an option. So all those things really end with the expiration of the right to redeem, which is why that one's in red. But let's move on and look more closely at kind of the different parts of the process and highlight some important things that go along with them. So
I have a question before you move on.
Go ahead. Absolutely. Go ahead.
There is one that says, when a borrower defaults on their loan, what would trigger or what would be a reason for a United States attorney to get involved and file a notice of filing an appearance and conditional waiver?
Well, so if I understand the question, it's just what defenses might there be or what circumstances might there be in which you would represent a borrower when you would get involved in court and try to help defend them in the case. Is that your understanding of the question?
I think so.
Yeah. Well, I'm going to pass on that for now because we're going to sort of talk about a lot of the defenses that exist as we go along. And I'm
Okay,
starting
so
to
we
get into
can
that right
answer
now.
later.
Yeah, yeah,
Okay.
and I think I'm going to be answering that question all along.
And what about
But if there's a follow-up
what?
question later, I can do that.
Yes,
Go ahead.
what does bankruptcy help with foreclosure? Because you mentioned it in the other one, in the previous slide about foreclosure, that could be another option. And it says, how does bankruptcy help with foreclosure?
Well, let me do that later too. And if I forget, then remind me, because that's
Okay,
again, I think it's
thank
better
you.
to talk about that a little later. Okay,
Okay,
so let's jump in and talk about what some of the requirements for filing are. Because bottom line, every requirement is also a possible defense. If there's a requirement by law that the lender do something and they don't do it, then that's a defense that we attorneys use. So, for instance, right here, before they can even file, so you can see at the top, I've kind of tracked the hypothetical timeline going back to January. And then June is the filing in the hypothetical. You have to give a notice of acceleration. For FHA insured loans, you have to offer a face-to-face interview with the mortgagor to do loss mitigation. Granted, that's, a subset of loans, a smaller set of loans. But then the big one is here in red. So beginning in January 2014, the Consumer Financial Protection Bureau issued regulations. They went into effect under this law called RESPA, the Real Estate Settlement Procedures Act. Bottom line, all you really need to know is the 2 bullet points it says here. Servicers cannot make the first notice or filing required for the foreclosure process until a mortgage loan account is more than 120 days delinquent. So basically what this is doing is giving breathing room, 120-day minimum before the case can be filed, so that the borrower can try to figure out if there's a way to catch up or deal with the situation. And of course, one way that a lot of borrowers try to deal with the situation is to file a loan modification application. And the second bullet point, as you see, says no foreclosure. No foreclosure can be filed if there's a pending loan mod app. So this is kind of the first category of cases that we take, or that could be referred to an attorney, whether it's us or someone else. If the borrower has filed the loan modification application and it hasn't been processed yet, and if notwithstanding that, the lender goes ahead and files foreclosure, starts the foreclosure case, that's a ground to defend the foreclosure, maybe even get it dismissed. So this is the first big one to be aware of. And I'm going to mention a few things like this along the way as we go through the timeline. So on our timeline, we have the complaint being filed June 1st. I don't want to read all this. Again, this is a lot of technical legalese that probably only lawyers can love. Sort of gives just the basic information that has to be put in a complaint. This comes from the statute. If you're an attorney, or if you want to play attorney and look at the statute, the sites are here. But basically, most foreclosures that are filed by now in Illinois, this section 1504 kind of gives a template, and the lenders follow the template. So there's not a whole lot of differentiation there when you see complaints. This is case law, again, I'm not going to go into, that has to do with capacity in which the plaintiff brings the foreclosure, as it says at the beginning. The only thing I'll point out is simply that, a lot of times borrowers will come into you, will come into us, will call and say, I'm being sued by this trust or by this bank or by this other entity I've never heard of. I don't understand. This doesn't make sense. Well, that's understandable, but it's not at all unusual. And there's nothing illegal about it. It doesn't usually necessarily raise any legal defense because, as probably most of you know, mortgages get bought and sold every day. So if you got your mortgage from Chase, good chance, it's transferred to someone else, to someone else, to someone else. So the plaintiff in the complaint can be completely different from your original lender. And as you know, the servicer who's contacting you every month and to whom you're sending payments, who's talking to you about a loan mod or talking to you about foreclosing, can also change. So these are issues we look at, but it's certainly not at all unusual that new names appear even during the foreclosure. Although if a new name appears during the foreclosure, that is more of an area where you want to possibly have a lawyer look at it, because the plaintiff who's prosecuting the lawsuit, they have to do something to show that this new entity is the proper party to continue the case. They can't just kind of change a name on a piece of paper.
Dan, I have a question regarding servicer, and it says, what options does a homeowner have if the servicer doesn't halt the foreclosure process when being reviewed for a workout?
Well, again, that would be a good referral to an attorney. So I'll just say now, give a plug for LAF. We're here in Cook County. Our peer in Northern Illinois outside of Cook County is Prairie State Legal Services. And then downstate, it's Land of Lincoln Legal Assistance Foundation. So contact or refer a client to any of us to take a look if you see that situation. A lot of our cases have to do with the lender plowing ahead with the foreclosure, even though there's a loan mod that has not been processed, and that's improper. They're not supposed to file in the first place, and they're really supposed to put everything on hold if, during the foreclosure, if a loan mod is application is submitted. So that's a good question. And by the way, I can't speak necessarily for Prairie State and Land of Lincoln, but here in Cook County, for us, for LAF, we have fairly high income guidelines for homeowners. We have grant money that allows us to represent homeowners at significantly higher incomes than, kind of our regular LAF legal aid income guidelines. Our regular LAF legal aid income guidelines are 150% of poverty, so that's quite low. But for homeowners, we can go all the way up to 80% of area median income. So, normally income is not a problem, or somebody being a too high income. So let me continue with the timeline. We're going to file our answer. Again, you'll see here a lot of technical citations. I mentioned capacity, which again is this entity. Do they have the legal right to be suing me? And again, just because they're a different name doesn't mean they don't, but it's certainly something we look at as attorneys. I'll just leave that at that. So in our hypothetical timeline, we've gotten to the judgment. Something that's important to understand, and a lot of attorneys and even judges get confused. The foreclosure judgment in a foreclosure case is not the end of the case. It is not the final judgment. You're not done or out of luck just because there's been a judgment. If you remember from the timeline I set forth earlier, the case was filed in June. You can have a judgment in September, but you still have at least 3 months after this before the home can go to sale. At least 3 months to do something. So that's important to remember. We're going to talk about a couple of the things that a lender has to include to get its judgment. And again, these also demonstrate defenses if they don't do it right. But before that, we have another poll. We're going to go to this next slide. And the question is, who is this? And Vivian's going to give you your options.
Okay, so pay attention. Who is this? And you're going to have 15 seconds to guess. Okay, I'm going to close the poll. And that's the result.
Okay, well this was my favorite poll question for obvious reasons. I got to be a little bit silly here. So I'm very proud of you all. 35% of you got the correct answer. Jeffrey Steffen. So just to remind folks, Jeffrey Dahmer, the first one, he was the serial killer from years ago. Don't need to get into all the grisly details. Jeffrey Skilling. It's actually kind of good that he came in second here, because he was a crook too, a financial crook from Enron. People remember the Enron scandal of years ago. Jeffrey Steff, well, I'll come back to Jeffrey Steffen, the correct answer. Jeffrey Tambor there at the end. He, of course, is the star of the Amazon dramedy Transparent, and he was also the dad on Arrested Development, great show for years. But Jeffrey Steffen is the correct answer. I don't know that my picture of him is actually what he really looks like in real life. It's just kind of a political cartoon version of Jeffrey Steffen, but he was like the robo-signing dude. So back in the day when all the foreclosures were being filed because of the crash, and it came out through the hard work of some legal aid and other attorneys in Maine were among the first to find this out. There was this guy Jeffrey Steffen from Ally GMAC, who was in a deposition admitting that he had, done like 1,000 affidavits a day, just stamping them, rubber stamping them. These were affidavits to support, motions for judgment of foreclosure to foreclose on people's homes. And obviously nobody was really scrutinizing the facts on them. And I don't think this guy was even a lawyer. He's like a paralegal, and he's just rubber stamping all these things. So that actually did lead to some good reform, some good changes in many states and at the federal level. And then there were, of course, the national lawsuits filed by the Department of Justice and the AGs. So here in Illinois, one of the main things it led to was that when you want to get a judgment now in a case, you must, as a lender, submit a pretty detailed prove-up affidavit. So an affidavit, from somebody other than a Jeffrey Steffen type, who can really attest to having reviewed the file and sort of verifying, the accuracy of all these numbers, and then breaking down the judgment into all these different line items, which is much more detailed than it used to be. It used to be maybe 3 lines instead of, a dozen lines. And this can be really helpful to homeowners and especially to lawyers. So for you guys, I guess I would just say that if somebody is at the judgment stage and, they've got the court papers and this is missing, that's a huge red flag. Or if there's just some wacky number or something that the homeowner is saying is just wacky or makes no sense, these are all kind of maybe, at least yellow flags that might say, hey, well, try to refer you to an attorney. The other thing that you have to do now, and you can see it says Rule 113. So in Illinois, we now have Rules 113 and 114. These are state Supreme Court rules. And these rules were implemented back in 2012, 2013, again, as a response to kind of the robo-signing crisis. So Rule 114 says, to get judgment, you got to do a loss mitigation affidavit, lender. You got to say if the homeowners applied for loss mitigation, and if so, what's the status? What was done to comply, and what's the status? So this is kind of our state version that sort of goes along with the federal reg that I mentioned earlier about halting the case, not filing in the first place, or halting the case if there's a pending loan mod app. The court should be apprised if the homeowner wants and has applied for a loan mod, and what's happened with that, and to make sure there's not dual tracking, as we call it, going on. But assuming all that's done properly, and the 3 months have passed since the judgment, the home will go to sale, and there has to be a notice with these various requirements. Again, I won't get into all the details, but a notice has to go out to every defendant, and the court will approve the sale unless notice was improper, or there was fraud or unconscionability, very rare, very hard to prove, or justice not otherwise done, which is a nice catch-all that does still give us lawyers some room to argue. And mostly that has to do with a loan mod that wasn't processed, or, we've done cases, and there are decisions in the law where, the homeowner called the lender, and the lender said, okay, we'll hold off on the sale. We'll give you an extra week. And then they went ahead with the sale anyway. And if that prevented the homeowner from being able to pay it off, things like that, then the judge will not confirm the sale, not approve the sale. But it's tough. It really has to be a situation where the lender itself did something wrong. So it's sad, but you know how it is. There's a lot of these cases where somebody got caught up in like a foreclosure assistance scheme, and they unfortunately wasted, $2,500, $5,000, sent it to some company in California who said they could save their home, and that money just kind of was flushed down the toilet. Unfortunately, that's not going to really help you here because, yeah, the homeowner got screwed, but it wasn't by the lender, so that's not going to hold up the sale. Here you kind of got to find something that was the fault of the lender, for an attorney to be able to use it. And this kind of just repeats what I said before, but again, the RESPA, loss mitigation procedures put into place by the CFPB in 2014 say, to quote the specific language here, servicers must consider and respond to a borrower's application for loan mod if it arrives at least 37 days before a scheduled foreclosure sale, and must act on the application before seeking judgment or going to sale. So actually, it's worth pausing and focusing on that 37 days for a moment because, if a homeowner throws in a loan mod app a week before the sale, the lender can go forward with that sale. There's nothing that says the lender has to stop and consider that loan mod app. The federal regulation says it has to be submitted at least 37 days before the scheduled sale. So again, timing is critical. The lender can always voluntarily agree to postpone the sale. It may sometimes do that, but you don't really have leverage unless that loan mod app is submitted at least 37 days before the sale. Now, remember I said earlier, in Illinois, under the statute, the sale can never occur until at least 90 days after the judgment. So that means, by definition, if we're still before the judgment and you submit a loan mod app, that should stop things. Again, even after the judgment as well, but it has to be 37 days before a scheduled sale.
I have a question here, Dan.
Sure.
People is asking, can a foreclosure judgment be reversed? Another
Absolutely.
one is...
Yeah, it can. And it would be, for instance, in that situation, if a loan mod app was pending and it was submitted in time, and then, either it went to judgment or it went to sale, then both of those could be challenged.
And the other one is a complete or partial application?
That's a very good question. The statute or the regs do say complete. So, that's tricky. If there's an incomplete application, that may not be good enough. Now, we've taken cases and fought them where we thought that the application had enough information to be considered complete, arguably, even though the lender was arguing it wasn't. So it's a little bit of a gray area. Also, if you submit an incomplete application, the lender under the regs is supposed to inform you promptly, I believe it's within 5 days, it might be 5 business days, what's missing. So we took a case where we felt like they had all the information, maybe it wasn't complete, but the lender had never responded. The lender just sat on it. The lender never said, oh, we still need ABC, right? And then about a month later, they went to sale. So we actually filed a motion and won in that one. So it kind of depends. It's supposed to be complete, but the lender's also supposed to tell you what's missing. So sometimes you can use that. So again, a lot of cases were sort of loan mod madness. The other thing is that, there may be a trial that's not converted into a permanent, and we do a fair number of those cases. So, as you know, sometimes the craziness is they've submitted a loan mod app, they got the trial, they made their 3 payments, they may make 4 or 5 or 6 or more. And then the lender just decides for whatever reason, oh, we're not going to convert to permanent, we're just going to foreclose or continue foreclosing, and we will fight those and get involved in those cases too. So I'm going to move quickly through the rest of this as we're sort of starting to run out of time. Just quick note here, I'm sure you all know HAMP ended in 2016, other than for FHA loans, other than maybe occasionally you might see one out there where they applied 2 years ago and there's still some really long ongoing struggle, but you can't apply for HAMP anymore except for FHA loans. But there's the Flex Mod program, and there's a site here, and there's proprietary mods, the the lender's own mods, which many of which look similar to the Flex Mod. So there are still loan mods being done, not necessarily as affordable as under HAMP, but I think still loan mods that can help a lot of people. And I wanted to throw this in real quick too. I guess these are some other examples where we got the sale postponed or actually vacated once it was held. We had one where there was an app pending for hardest hit funds, and the lender was kind of ignoring it or not cooperating and went to sale, and we got that vacated so that we could go back and try to get the use of the hardest hit funds to be able to deal with the mortgage situation. And then the second bullet point here is kind of the things I mentioned before, the situations where there's just some version of, the lender told me they'd help or gave me time or said if I do this, and then kind of reneged on that. These are just the case sites if you're interested for those types of cases where the lender, had agreed and then kind of reneged and went to sale anyways. And the appeals court said, no, you can't do that. That's not justice. We're going to vacate the sale. So with the right facts, we can sometimes do that. The only thing I'll mention here is this first item, because it can be confusing. Again, even sometimes to lawyers and judges, and certainly when a layperson reads it, they don't know what it means. So if there's a sale, the question often becomes, the person wants to know, is there a deficiency or not? So, right, if the debt was $100,000 and the home was sold for $75,000, that leaves $25,000. Okay, so there's potentially a deficiency of $25,000. And so people understandably are like, well, can they come after me personally for this? Can they come garnish my wages or seize my car or whatever? Well, the answer is only if there's a personal deficiency. A lot of times there's a deficiency in the final order approving sale or the order confirming sale, but it's in rem. That means against the property, fancy Latin legal term. So basically just in whatever way, shape, or form, if somehow some more money comes out of the property, they can get it, but not from the person. So, we used to say years ago, in Cook County at least, they never get personal deficiencies. In recent years, that's changed, and we have seen more of them. I think it's more common not to have a personal deficiency, which is good for the homeowner, but it definitely can sometimes happen. So homeowners at the end of the process, if there has been a sale, they do want to monitor this. They want to get the court documents and see. And it's also important because this sort of goes back to the bankruptcy question. People are sometimes like, well, I was just sued in foreclosure, so I'm going to file bankruptcy just to get rid of the debt so that I don't have it hanging over me. I know I can't save the home, but I'm going to file Chapter 7 and just get rid of the personal liability. Well, no. You should wait in almost all situations to the very end of the case and see if there even is a personal deficiency, okay? Because if there's not, and the debt's been satisfied entirely by the home, or that's all the lender gets, you may have wasted filing a bankruptcy. So generally, we really caution people to wait to the end of the case and see if there's a deficiency that they need to get rid of to a 7. Okay, that's a 7. I'll come back to filing a Chapter 13 bankruptcy in a minute. Try to make time for that. We're getting near the end. The only thing I'll say here is really that second bullet point, personal jurisdiction. If you've got a client who's like, I never got any of the paperwork, it's a judgment, or I got a notice of sale, but nobody ever gave me the court papers, then obviously you want a lawyer to look at that, because in some but not all cases, you may be able to dismiss the case, wind it back to the beginning. There's some good law here that's helped us to do this in a few cases in recent years. So we'll talk a bit about reverse mortgages, HECMs, because we do a lot of these. This is the big trend. You probably know, foreclosures and HECM cases, home equity conversion mortgage cases, or reverse mortgages, a real surge. And we are doing these cases both because the original borrower has died, we're trying to represent either the heirs or a surviving spouse, or the next slide, a couple slides later, talking about the situations where it's the original borrower and they've just defaulted in one of those ways we talked about earlier. But I think we have a poll coming up. So
yeah, what about if we launch the poll?
We'll go to the poll. Yeah, let's go to the poll.
And let's see what people think about it.
I'll put it there, and then you can also do it. Which of the following is not a requirement for a surviving spouse? So say that husband dies and he was on the mortgage and note, and the wife was not on the mortgage and note because she wasn't 62 or because she was taken off. There's a program that HUD has in place, not easy to get, but in theory at least, the surviving spouse, as we call her, usually the widow, can remain in the home. But this question asks, which of the following is not a requirement for her to remain in the home? Having a credit score of at least 650, being on title, being current on taxes, or being current on insurance. So I'll let you go to that poll. That's our final one.
Okay, let's get 10 more seconds, and we're going to close the poll. Here are the answers.
Very good. I outsmarted very few people here. The correct answer is the first one, having a credit score of at least 650. So again, what we're focusing on here is just leave the answers there if you could, Vivian, for a minute. We're focusing here is the surviving spouse, most often the widow. We have like 6 of these cases right now. The federal statute under which HUD set up the entire reverse mortgage program many years ago says that you have to protect surviving spouses, like the widows. You can't foreclose when the husband dies, when the one spouse dies. You can't foreclose. Unfortunately, HUD set up the entire program 180% or 180 degrees in the opposite direction. They set it up to where lenders have to foreclose if the one spouse dies and the other spouse who wasn't on the mortgage remains. So HUD was sued years ago. Federal court said, HUD, this is unlawful. Advocates like ourselves have been fighting HUD ever since to try to get HUD to do right by these surviving spouses. Newer reverse mortgages that were transacted as of 2014 correct the problem going forward. However, if you have an older mortgage, like the 6 that we have, that were transacted before 2014, we've got widows who, HUD is making it still hard for. And there's this program, the MOE program, that's supposed to help these widows, but it's just really hard to qualify for. So we are challenging all these rules that HUD put in place that makes it hard to get through this maze to get to the end and be able to stay in your home. But in theory, if you're current on taxes and insurance, if you're either on title or you can get on title because you inherited the property, you're supposed to be able to. They look at those things and they're supposed to say that you can stay. The credit score one, yeah, that was my red herring. Credit is irrelevant for remaining in the home.
So I have a question regarding that, and it says, what document is required for people with dead parents to be able to claim the home out of foreclosure?
So did you say their parents had died? Was that the question?
Yes, the parents died, and
okay, so the heirs. So heirs. Mm-hmm. So kind of not even so much the surviving spouse particularly, but heirs. So the problem is more and more that the lenders are requiring you to go through probate, at least in Cook County, at least with the lenders we've dealt with. So, years ago, it seemed like more often you could get away with just doing an affidavit of heirship, just the statement, that we do these in our office. It's just a statement of who the heirs are and, who's inherited the property. And I'm talking about cases without a will, right? More commonly, at least, we see cases where there's no will. So it's just like the statute tells you who the heirs are. And you used to be able to do a statement like this, an affidavit of heirship, and that was good enough. That just hasn't been the case in our experience now for years. And so pretty much if somebody comes in to our office and they're an heir, and they want to save the home, somebody's got to open up a probate case. And we don't really do probate, like decedent's estate probates. I mean, we do a few when we have to. Sometimes we find private attorneys to help us. They kind of do that part of it, maybe for free or reduced rate, and then we kind of help with the foreclosure. Sometimes with a really messed up, complicated heirship situation, there's 8 siblings and they're all fighting, we just send them up to a probate attorney straight up, because unfortunately, I just think for the most part, you really have to go through probate to clear up the title to then be able to deal with the foreclosure and with the lender. That's unfortunately the answer that I think is the one I have to give. Yeah. So let me wind up here. So to talk about the other kind of reverse mortgages where it's the original borrower, if they haven't paid the taxes or the insurance, or sometimes there's a problem with the property that they haven't been able to fix, those are other reasons that can go into foreclosure. We do a lot of these cases, as you can see by this slide. What do we do? Sometimes we try to seek a reinstatement plan with the lender. Sometimes, second bullet point, we can do the at-risk extension, the 1-year deferral, if the borrower is 80 or older and faces a medical hardship, and that can be renewed. We've done one, I think now three in a row for one client. And then the final one there is file a Chapter 13 bankruptcy. So, good place to speak about bankruptcy now. So whether it's for reverse mortgage or for a traditional forward mortgage, basically any homeowner who has decent income and has the ability to make a plan payment, because a Chapter 13 requires a 3 to 5 year plan. Okay, unlike a 7, you're not just discharging stuff. You're paying your creditors over 3 to 5 years and trying to stay in the home. We'll take a look at those cases, and if the numbers work, we'll file those cases. And basically what it means is, in a 3 to 5 year period of time, through your monthly plan payment, you have to be able to catch up on whatever your secured debt is, your mortgage debt. For reverse mortgageors, it can be just they're behind on taxes $2,000, or they're behind on insurance $3,000, or something like that. It can be a relatively smaller amount. Sometimes for forward mortgage borrowers, they lost a job, so they got $10,000 behind. Okay, now they got a new job, so now they have income. They can make their payments and they can catch up a little bit over time, but they just need time. So that's when a Chapter 13 works. But it's critical to understand. You've got to make all your regular ongoing expenses and payments, food, travel, housing, utilities, car, etc., and a payment that over 3 to 5 years will catch you up entirely on your mortgage debt. So that's when we file Chapter 13, and we're happy to take referrals for those cases. And I believe Prairie State does some Chapter 13s, and I'm not sure about Land of Lincoln, but reach out to them if you have a case like this and see. I believe they do. So let me get to, we're at the end. So when does it make sense to make a referral? I've sort of talked about this as we've gone through. Foreclosure was filed when the loan mod was pending, or a judgment was sought when the loan mod was pending, or a sale was sought when the loan mod was pending for more than 37 days. Loan mod shenanigans, right? The failure to convert, et cetera. Reverse mortgage foreclosures of the types that we were just talking about. Any hint or whiff of fraud, we're willing to take a look. And bankruptcy in the cases that I mentioned. And I do say here at the bottom, but for all of these, at least for us, we do need there to be basic financial means to afford the home. So we're not going to take a foreclosure, where somebody just has little to no income, and the point is just, to stretch it out another 6 months. Rare exception, maybe a senior who's like trying to get into senior housing and needs more time. That's about it. So the last slide literally is the next one, which has my contact info again. I'm sort of saying here that if you have a client and you want to make a hard referral, like you really think there's something here, feel free to call me or email me. Or even if you have a question, you need a consult. For the soft referral, where you're maybe not quite as sure, somebody just wants a referral, but you don't necessarily see much there, you can still give them our main number. Or people can also apply to LAF through Illinois Legal Aid Online at the URL there on the bottom. So I don't know if we have time maybe for a couple questions. I don't know if there are any more questions, Bibian.
Yes, I have a question here. One is only says, what about what about HHF assistance? And I have another one that it says.
Wait.
Yes.
So the first FHA? So like FHA insured loans?
Mm-hmm.
I mean, yeah, there's loss mit for FHA. There's FHA HAMP. So again, if you've experienced that somebody was denied and you think they shouldn't have been denied, or there's some kind of craziness with their application for a loan mod, we could look at that. We could also, if there's the loss mit requirement, face-to-face loss mit requirement, which is a little more robust with FHA folks. So if they never got a request or an offer to do a face-to-face meeting, we can use that as a defense. We also have some really weird cases now with partial claims that are being accelerated. These are the amounts HUD pays off that are supposed to just sit there till the end of the mortgage. And we've got one case where HUD's coming after somebody and actually seizing their taxes, we think prematurely. So that's very weird, but we're doing that. So those are all kinds of FHA cases we could take a look at.
And there is another one, and I think this is referred to the HECOM because it says, will an affidavit of death and heirship work instead of probate?
An affidavit of heirship, will that work instead of probate? As I was saying, most of our experience in the last couple of years is no. I mean, you can always try and see if the lender will accept that. We just find that lenders are not accepting that as much as they did, in years past.
And we have the other one. Remember when we started, I sent you to the chat, but it says, when a borrower defaults on their loan, that would trigger on what would be a reason for the United States Attorney to get involved and file a notice of filing an appearance and conditional waiver.
Oh, for the U.S. Attorney to get involved?
Mm-hmm.
I really don't know. I feel like that's I need more. You know what? How about if that whoever asked that question can contact me afterwards, because I'm really not sure what they're talking about exactly, or what kind of situation or what kind of mortgage. But they can feel free. Anybody can feel free to email me if there's other questions they have, or that one.
Yeah, I think that when you have like a specific questions, because I'm sure they are talking about their clients, so I think the best way to do it is like send an email to them, or just refer your client to LAF, and in that way they can get the assistance.
Yeah, either way, but like as you said, I mean, if you're not sure, just email me, and sometimes it's a quicker way to figure things out or see if there's something there or not. Yeah.
Yeah,
so
I'm not sure.
I think we're done.
Yes, there is one. Then one more. I'm not sure the person hasn't answered yet, but I think so. HHF assistance for a reverse mortgage foreclosure?
Yeah, so hardest hit funds,
Mm-hmm.
as of last year, I think, we were actually among those, and Housing Action Illinois was among those who were advocating to hardest hit fund, hey, make this available to reverse mortgage borrowers, because they weren't originally. But as of last year, they do. So if you have a reverse mortgage borrower who's behind on their taxes or their taxes and their insurance, that is a possible way to get money to catch up, is from hardest hit funds.
Okay, so I think this is all the questions that I have. Thank you so much, everybody. Thank you so much, Dan and LAF.
Thank you.
This has been a grateful information. Remember, I'm going to send it to you to your email, the PowerPoint, and also this recording. If you have any other questions later on, please send it an email to Dan. He's the expert in legal matters, and I talk to you next time with the next webinar. Thank you so
Great,
much,
thanks.
Dan.
Thank you all.
Have
You're
a good
welcome. Bye-bye.
afternoon. Bye bye.